Today I've got with me Beth Woodward from Neves Solicitors. And Beth, you specialise in family law.
Yes, I've specialised in family law for the last 17 years and I'm a partner at Neves.
And if a client comes to see you and they want a divorce, what's the first thing you say to them?
What are your priorities? I need to understand the background to them coming to see me, whether there are children involved, and we need to understand together what the financial implications of a divorce is.
Okay, so how long does it take usually to get a divorce, and what sort of process do you need to go through?
It takes 3 or 4 months to decree nisi, and 6 weeks later you can apply for decree absolute. Application is made to your local county court on paper, so there's no need for you to attend.
And that paper application is called the petition, I believe.
Yes.
And the person who makes it is called the petitioner. And you mentioned 2 other terms, decree nisi and decree absolute. Just explain what those mean.
Decree absolute is the final stage of the divorce when you're free to remarry, you're legally no longer married to each other. Decree nisi is the stage before that, when the judge is certified that you're entitled to a divorce.
So you put in your petition, and in order to be granted decree nisi and then decree absolute, what do you have to prove, what do you have to show in law?
So there's only one ground upon which to base a divorce, and that is that the marriage is irretrievably broken down. To do that, you need to rely on one of 5 facts. Those facts are that you've been separated for 5 years, desertion. I've very rarely used that divorce. It's usually more trouble than it's worth. That you've been separated 2 years and you both consent to a divorce. Sometimes people come in and see me and refer to a no-fault divorce. That's the fact that they're referring to. Then there's adultery or unreasonable behaviour.
Okay, so you need to show that the marriage is irretrievably broken down, and just take us through those 5 facts which can prove that.
So you've got 5-year separation, desertion, 2-year separation by consent, adultery, unreasonable behaviour.
Okay, great. Let's go back to the process now. We said that you need to lodge the petition, a paper application, at court. What other documents do you need to lodge at court to get your divorce?
So there's a statement of arrangements for children which sets out the arrangements that you and your husband and wife have come to for the children. It's advisable to get your husband or wife's agreement to that, and they can sign the statement themselves as well. After all, the children are the most important thing to consider within a divorce. Then there's also the marriage certificate. You need to file either the original or a certified copy, and a court fee of £340.
Okay, now you have the petitioner, the person who's asking for the divorce, and then you have the respondent, their husband or wife. And I believe, Beth, at different times, sometimes you'll work for the petitioner, sometimes you'll work for the respondent.
That's
so
right.
You see both sides. Now, obviously, the relationship between them is very important. It's important to get agreement between them. How would you handle that relationship, and how would you go about trying to reach agreement between the petitioner and the respondent?
So I would always say to my clients that it's important for them to try and have a discussion with their husband and wife so that they can agree the fact upon which they want to base the divorce and try and do it in as amicable way as possible. There's no merit in being confrontational for the sake of it, frankly. Then I will always write to the respondent before lodging the divorce petition, really to soften the blow, so that the first they hear of it isn't receiving a divorce petition from the court. And in that letter, I'm at pains to make it clear that this is a process that is maybe not very nice, but necessary in order to obtain a divorce. And also, if you're going to be relying on the fact of adultery or 2 years separation by consent, you really need to establish before you've lodged your petition at court whether or not the respondent is going to cooperate and consent.
Okay, so as a solicitor, you're really trying to get the petitioner and the respondent to reach agreement. You're trying to help them to do that.
Yes.
But I guess sometimes that's just not possible. So if the petitioner and the respondent can't agree, what happens then? So
the respondent has essentially 3 choices. He can complete the acknowledgement of service form that he receives from the court, saying yes is the respondent, and he doesn't intend to oppose the divorce. If he wants to, and the fact upon which the divorce is based is unreasonable behaviour, he can say there that he doesn't necessarily accept the allegations made. Alternatively, the respondent can try and forget that he's ever received it, but that's not advisable because the petitioner can usually get the divorce anyway. Thirdly, he or she can defend the divorce, but that's not common because it's quite expensive, and you'd essentially have to show that the marriage hasn't irretrievably broken down when the other party to the marriage is saying that it has.
Okay, so the bottom line is nearly always, if you want a divorce, you can get it.
That's right.
Okay, that's great. So if someone wants to come and see you and get you to work for them in their divorce, how do they contact you?
Through the website, www.nevesllp.co.uk. My email address is beth.woodward@nevesllp.co.uk, or my telephone number is 01908 304 560.
And you're one of a team of family solicitors at Neves. How many of them are there, and where are they based?
We have 5 family lawyers based at our Harpenden, Luton, Milton Keynes and Northampton offices.
And if someone would like to contact one of them, how should they do that?
Via the website or through me.
That's great, Beth Woodward. Thank you very much.
Thanks.